to the other case that affects Kenya, and that is the one concerning Deputy President William Ruto. And judges in The Hague have now ruled that the court is perfectly in order to compel hostile witnesses to testify. Ruto had appealed in an earlier decision requiring reluctant witnesses to testify. Edith Kimani has more from The Hague.
It took just 20 minutes for the appeal judges at the International Criminal Court to deliver what has been described as a landmark ruling.
The appeals chamber finds that Article 64(6)(b) of the statute gives to a trial chamber the power to compel a witness before it, thereby creating a legal obligation for the individual concerned. Accordingly, the trial chamber did not err when it concluded that it was vested with such a power, and the first ground of appeal is therefore rejected.
That clinical statement marking the culmination of what has been a back and forth between Ruto's defense team, prosecution, and 9 witnesses. The prosecution witnesses had previously made damning claims against the deputy president, opted out of the case, claiming their testimony had been fabricated. The witnesses claimed the prosecution had encouraged them, but Bensouda's team has raised concern over the timing of their withdrawal. 8 of the witnesses withdrew after their identities were revealed to the defense. The judgment today means that the 9 will now continue to testify.
The appeals chamber finds that Article 64(6)(b) of the statute expressly states that trial chambers have the power to require the appearance of witnesses before the court. The plain meaning of the term require is something more than a voluntary action expected from someone else.
Prosecution will now have the arduous task of building a case with the witnesses it deems hostile. Already, 3 of the 9 witnesses have testified via video link, although prosecution now has the added task of disapproving the witnesses' claims that their testimonies were fabricated.